So, obviously, something that we don't want to think about, but it's a sad reality that does happen. If someone makes a claim against my estate, how might I defend that?
So, estate litigation's probably the single biggest growth area in litigation in the Supreme Court at the moment.
Wow.
People are dying with more and more assets, particularly superannuation interests. And I guess, in answer to your question, it depends on what kind of claim the person's going to run. So these are the main ones. There are some kind of smaller ones, but in essence, the first kind of claim that I look at is whether or not the will or the document that you're challenging is actually valid. So it's a validity claim, and basically in that validity type argument, there's kind of sub-arguments that are on. One is that the will maker lacked testamentary capacity. So that is, they don't have the capacity to actually understand what a will is, what a will does. They don't know what their assets are. They don't know who their family are, or there's these diminished capacity type cases. So if that's one way that a will might be said to be not valid. Another way is that it could be said to be not valid is through what's called testamentary undue influence, and that is like coercion or overbearing the will maker's free will. And it's more than just pestering. You get your kids pestering, putting their hand out, mum, dad, leave me some money. It's got to be, a real persistent. It's almost tantamount to fraud. It's not leaving the person with, peace and quiet to get on with it. They might be in hospital. They might be, it's heavily reliant on this person for shopping, or they might have a disability, or and they're being abused because that's the only person that can actually care for them, is forcing them to sign documents that they don't want to do. They're concerned that if they don't sign them, then they're going to lose that support network and that kind of thing. So so there's lack of essential validity or lack of validity of the document on the basis of testamentary incapacity, undue influence, and the third, another one is a lack of knowledge and approval. So this is a case where the person has capacity, they're not being influenced, but they simply don't know what they're signing. So they might be blind, they might be or vision impaired, they might be under the effects of drugs or alcohol, they might not speak English as their first language, so their kids or someone's telling them this is, I don't know, TV magazine subscription or whatever, it's actually a will, and they're signing off on that. So they don't know of or approve of what's in the document. So those are the main ways that you might strike out a will on the basis that it's not valid. Now, looking at it from a totally different perspective, where you say, well, okay, the will is valid, but it simply doesn't make provision for me as a dependent or as a child or something like that. There's an act called the Family Provision Act, and it's in WA, and basically what it was originally designed for was when they abolished dower and courtesy rights of widows. They had protection because obviously under dower, when the husband dies, there was some provision being made for them after death. So when they got rid of that system, they had a safety net. It's a safety net system, and it's literally to stop originally widows and infant children being left without proper and adequate provision to maintain them when the deceased had enough assets to do that. People were giving their stuff away to the church or the local bowling club or whatever, and leaving people destitute on the estate and other people. So it was essentially saying, well, people can do whatever they want with their wills, but if people are unreasonable in not making provision for their dependents, then there's a mechanism for them to apply to the court.
Right.
And so that the categories of applicants expanded over time as a more modern, progressive society and a bit more flexible.
Yeah.
So they've gone to not just infant children, but adult children and a variety, dependents and de facto partners and same-sex couples and that kind of things over
Right.
time. So from a family provision perspective, the court will look at whether proper or adequate provision's been made for them, and then they will look at what is proper and adequate provision based on the size of the estate, the nature of the relationship that they have with the deceased, what are their actual needs, was there any estrangement, was there any disentitling conduct, were they fighting each other, was it, those kinds of things, and they kind of holistically decide whether or not they're going to exercise their discretion to make provision.
Gotcha.
So coming to your question of how do I defend against a claim, I guess it depends on what kind of claim is being run.
Sure.
The short answer is structuring your assets. I'm doing my PhD thesis on the effect of what they call non-probate wealth transfer, or non-probate transfer, which is where you're transferring assets without it falling in the will environment in the estate. So, for example, superannuation is a trust on its own. That's where you get the expression, my trustee in super. That could be paid directly to a dependent. I might have a life insurance policy that pays directly to a particular person. I might have a joint bank account where I add you or whoever I want as my beneficiary as a joint bank account holder, and it will pass by survivorship.
Yeah.
And the same with real property. So you can add a joint tenant onto your title so that when you pass away, the house actually transfers over. And so if you do that, there's other ways like creating family trusts and putting assets into companies and all these sound like wonderful things. All of them can really, really complicated. They create stamp duty issues, capital gains tax triggering events. It complicates people's lives. But if someone's absolutely adamant that they want a particular person not to challenge a will, then those are the kind of things that you can start to look at. You're getting kind of detailed advice, and you usually get a big stamp duty bill and stuff like that. So it can be done, but